Assalamualaikum warahmatullahi wabarakatuh. My name is Fakhirah Binti Hapizi, metric number UDE20 Law in Malaysia is mostly based on the common law legal system, which means that English law forms part of the laws of Malaysia. The extent to which English law applies in Malaysia has been stated in Article 160 of the Federal Constitution, which sets out the definition of law, which includes common law insofar as it in operation in the Federation or any part thereof. In Section 3 of the Civil Law Act 1956 present the definition of English law, which is defined as the common law of England and the rules of equity, as well as English statutes that has been prescribed.
My name is Adilla Izzati, Binti Mustaffa. My matrix number is UDE200072. Okay, I want to present about common law. First, I want to talk about the law of Malaysia can be divided into two types of law. The first one is written law and the second one is unwritten law. Written law are law which have been enacted in the constitution or in a legislation. Unwritten law are law in which are not contained in any statute and can be found in case law, in case decisions. This is known as the common law or case law. Okay, common law is basically made by the local custom of the British. Those customs are commonly used throughout the country from which the term common law is derived. They are distinct from the local custom used in isolated areas. The purpose is clearly to standardize the whole country. The common law was further developed by the courts when judges made decision on a particular matter. The decision given by the judge became a kind of guidance or precedent when a similar issue arises again.
Hello, my name is Nurdiana Binti Ridzuan from Section 2 with metric number UDE200105. I will explain about the equity rules. Equity, which means justice, and it was a body of regulation that the first developed by the Lord Chancellor, which is the King right hand, and by the Old Court of Chancery at the end of the 15th century. Unlike common law, equity is not a complete rule that can exist on its own. It appears by being a supplement to the common law, which is to correct the defects and mitigate the harshness when facing with a petitions alleging injustice suffered at common law that the Lord Chancellor did not decide according to the accumulated body of judicial precedent, but according to Christian precept of fairness. Equity is also a system of discretionary justice. If the plaintiff is found morally unfit, the plaintiff will not be provided a fair solution. The fair solution proposed is order, particular performance, rescue, and correction, with trust as the primary contribution of equity. When general law and equity have a conflict, equity should always prevail. Thank you.
My name is Nurfarah Najihah Binti Nasri and I am from UDE20 Section 2. My metric number is UDE200106. English law is part of Malaysian law. The application of English law begins during British co-colonization over Penang in 1786. When Malaysia was formed in 1963, there were 3 statutes that provide for the application of English law. The 3 statutes were then consolidated in 1972 into one statute known as the Civil Law Act 1956 at 67 revised 1972. In Civil Law Act 1956, Section 3(1), it provides that for the general application of English law, it states that in West Malaysia was applied the common law of England and the rules of equity as administered in England on the 7th April 1956. In West Malaysia, only exist English common law and rules of equity is Lee Ki Chong v. 4 nombor ekor Sendirian Berhad. In this case, according to Lord Russell Kilwan, the present purpose, it appears that the Civil Law Ordinance 1956 Section 3 adopt English law as administered as its effective date. So the any subsequent march in an English authority is not embodied. Next, Jamil bin Harun v. Young Kamsa and Anor. The court laid down the principle that though the subsequent development in English law strictly not binding, local courts may accept subsequent English authorities if, in their view, it is desirable to do so in the absence of local statutory provision or judicial guidance. And the last one is Chow Chun-Neo v. Spottiswoode. The court held that the English superstitious uses at 1547 and the Mormon at 1531 and 1735 were not applicable in the street settlements, while Section 5 CLA 1956 provides for the application of English law in commercial matters. In all questions or issues which arise or which have to be decided in the states of West Malaysia other than Malacca and Penang with respect to the law of partnerships, corporation, banks, land and sea, marine insurance, average life, and fire insurance. Generally, the law to be administered shall be the same as would be administered in England in the like case at the date of the coming into force of this Act. If such question or issue had arisen or had to be decided in England, unless in any case other provision is or shall be made by any written law, this Section 5 introduces applicable of the whole of English law, common law, rules of equity, and statutes in West Malaysia, therefore greater reception of English law in commercial matters. Thank you.
Hello, my name is Nurul Nadia Syazliana Binti Zainuddin. My matrix number is UDE200111. So, in 1963, which when Malaysia was formed, Sabah applies English law, which are the application of law ordinance in 1951. Section 3(1) provides that the courts in Malaysia shall apply the common law as well as rules of equity existing in England in the absence of written law on the first day of December 1951 in Sabah. The condition of the application of English law in Malaysia is suitability to the local circumstance. English law is applicable to the extent permitted by local circumstance and inheritance, subject to codification and necessitated by local circumstance. This can be seen in the case of UMBC versus Syarikat Batu Sina, where the court held that the English law that would like to be applied in Malaysia must be suitable with the local circumstance and local inhabitants. The judge also held that we will develop our own common law by directing our mind to the local circumstance and local inhabitants.
Assalamualaikum, I'm Shamimi Binti Rani, matrix number UDE200098. So in section 3(1), it provides for the general application of English law. It states that in Sarawak they apply the common law of England and the rules of equity together with statutes of general application as administered or enforced in England on the 12th day of December 1949, however, subject to subsection 3(2), provided that the said common law, rules of equity, and statute of general application shall be applied so far only as the circumstances of the state of Malaysia and their respective inhabitants permit, with subject to such qualifications as local circumstances render necessary. Section 3(1) provided that in the absence of written law, the court in Malaysia shall apply the common law and rules of equity in existing in England on 12 December 1949 in Sarawak. This actually reflects the pre-independence incorporation by the British of their legislation into the colonial territories of Malaya, Sabah, and Sarawak. For example, in the case of Pushpa versus Malaysian Cooperative Insurance Society, decided that Section 3(1)A CLA 1956 allows common law and rules of equity and not statutes of general applications, which includes in Sabah and Sarawak. In this case, the plaintiff sought to invoke an English statutory provision to revoke a nomination by her deceased husband in his life insurance policy that meet before their marriage. Then the judges reject on the ground of Section 31A.
In the absence of local legislation, Section 5(1) of the Civil Law Act 1956, Principle of English Commercial Law as it stood on 7 April 1956, all questions or issues that occur or are resolved in the states of West Malaysia, other than Malacca and Penang, shall be the same as would be administered in England in the like case at the date of the coming into force of this Act, if such question or issue had arisen or had to be decided in England, unless in any case other provision is or shall be made by any written law. Section 5(2) of the Civil Law Act 1956, which applies to the states of Penang, Malacca, Sabah and Sarawak, says that English commercial law will apply to the matter which has to be decided in the named states as it would in England. That's all from me. Thank you.
In Section 6, even though under Section 5 it provided reception of English law for the commercial matters, Section 6 expressly excludes the application in Malaysia of the English law concerning land tenure. This section was enacted because it intended to prevent the wholesale application of English law under Section 3(1) to land matter in Malaysia, since there are already local legislation concerning land matters.
Assalamualaikum, my name is Hanie Binti Aidi. My matrix number UDE200130. So for conclusion or summary of English law, first we have Section 3 and Section 5. First, overall, in Section 3(1), it states that Malaysia apply the common law existing in England and the rules of equity as 7 April 1956, while for Sabah and Sarawak, together with English statutes. For Sabah as 1st December 1951, and for Sarawak 12 December 1949. So in this section, there are application of English law subject to several qualifications. First, we have absence of local legislation. Second, cut off dates, and the third one, local circumstances. So for example, basically, what if there is a lacuna in our local law system, the judges will referring to the all cases that is in England rather than the latest one as administered on 7 April 1956 in West Malaysia. So if there is no lacuna, the judges will not going to refer the English law, but the judges will give priority or opportunity to our own law system. Move to Section 5. So in this section, for West Malaysia, other than Penang and Malacca, the judges will refer to the English law as 7 April 1956. It means that the judges will be referring to these cases which has been decided before 1956. For Sabah, Sarawak, Penang and Malacca, the judges will refer to the latest cases that existing in England. So overall, in short, for West Malaysia, except Penang and Malacca, the reception of English law in commercial matter stops at the cut-off dates because of cut-off dates. For the other one, which are Sabah, Sarawak, Penang and Malacca, there is continuing a reception of English law in commercial matter. So that means the judges will refer to the English law to make decision up to today. Thank you. That's all from me.